Okay.
And give people, it sometimes takes 30 seconds or so for the audience members to get connected once we do that. So let's give them a chance. Okay, looks like
We have some attendees still coming in.
still
That's
trickling
nice.
in.
Okay, we'll go ahead and get started then and bring our meeting forward. And it's the February 25th, 2021 CLRC meeting. Let's go ahead and begin. So the first item on the agenda is minutes. And just to, I guess, before we start, just looking at the number of attendees, if you have something to say, then there's a little button on the bottom of, it should be on the bottom or it may be on the side of your screen, and you can raise your hand. And then Brian is going to act as the moderator, and we will try to go ahead and acknowledge you and have you join the meeting as soon as possible, or as soon as, when it's appropriate based on our meeting agenda.
It's our practice to work public comment in sort of at appropriate intervals in the course of discussion rather than at a fixed time. So it'll be obvious when we're working through the material that it would be a suitable time for you to raise your hand, or not suitable, as Commissioner Carrillo is demonstrating. David, did you have something?
And then if I can just also remind all of the commission to members that to make sure to mute yourself if you're not saying anything, just to be mindful of background noises. And I see Kara. Hi, Kara. Nice to see you. And then David Carrillo, where are you? I don't know. Oh, there you are in the middle. You moved. You wanted to say something?
I was going to move to adopt the minutes.
Oh, we haven't even started. Agenda item 1. Okay.
You brought them up.
I know. I interrupted my own self, so I'm going to put my interruption card down.
And
I appear to have a second.
Okay.
Staff has no proposed corrections, so the minutes as drafted and distributed are what's on the table.
Okay. All those in favor of adopting the minutes as is, say aye. Any objections? Any abstentions? Okay, they're moved. We'll adopt them, and that item is complete. Now we're on to the item number 2, administrative matters. Brian, you have a report for us?
Yes. First, I'd like to officially welcome Kara Jenkins, Legislative Counsel, to her first meeting as a commissioner. Legislative Counsel is a member of the commission by statute, and so as soon as she was appointed, she became a member. And I know that her schedule is very busy and she gets pulled in many directions. So I'm greatly appreciate that you're able to be here, and understand completely if you need to duck out at any point.
No, we keep you here, Karen. No, but it's good.
Just
Welcome, Karen. Karen, when did you start? I think, what, January? Oh, no.
I was elected in December. I was appointed.
It's only been 2 months. Wow. I've seen her in a couple of meetings because I'm on another committee. That's so funny. Okay, well, good. Nice
It's
to
all
meet
a blur,
but you're doing a great job, and it's good to see you here. We miss Diane, so this is perfect. We need to have your voice here.
Thanks for having me.
The other things I have to report are just a few administrative items. One is that in the past, there have been donations made by the former executive director, Nat Sterling, to King Hall Law School at UC Davis. He's an alum there, and he has a few times before made donations, which he earmarks specifically to pay for student employees of the commission from King Hall. So it's kind of a synergy thing that he's set up where we can get employment for their students and receive the benefit of their work without having to pay for it ourselves. And Nat has, I'm told, made another donation for that purpose. We're in the process of figuring out administratively how to work with it and use it. But I'm hoping and expecting we'll have a summer student this summer who will be paying. And so not an externship. That's nice. That means we can give them less interesting work than if they're an extern where it has to be academically enriching. We're in the process of sort of realigning our administrative staff a little bit. When the the commission was assigned responsibility for the new Committee on Revision of the Penal Code. That came with some money and positions. And one of those positions was an entry-level administrative office assistant. We did not fill that position because at the time we were getting ready to do it was when the quarantine was kicking in, and it just didn't seem workable to try to find work for an office assistant when we didn't have an office. We were all working from home. But we're now looking at ways in which we could structure that position for remote work, and probably getting ready to start recruiting for it pretty soon. And that's part of, like I said, sort of a realignment of the administrative tasks, because now that Barbara and I are responsible for both the commission and the committee, it would be helpful to be able to drop some of the administrative work that we otherwise would be responsible for and sort of push that down onto our existing administrative analyst, Deborah Larrabee, who's in the audience. Hi, Deborah. And so we're looking at promoting Deborah to a higher level administrative classification so she can take on duties that were formerly performed by me or Barbara. And then she would drop some of the lower level administrative duties and we would assign those to the office assistants. So we're just sort of pushing everything down and creating another level. Hoping to get that going and in place in a couple of months. That should help us sort of spread the load a little more easily. The other thing I would mention is that the committee there's a proposal in the governor's budget for the Committee on Revision of the Penal Code to receive a couple more attorney positions. And we're going to start recruiting for those fairly soon, contingent on enactment of the budget in that form. So we're going to start actually before July 1 with the express contingency that we can't hire if they don't authorize the positions and money. But so we should be growing our staff on the committee side unless something unexpected happens. And so if any of you know of any attorneys who are specialized in criminal law, criminal justice type issues and might be interested in working for a reform body with that subject matter jurisdiction, you could direct them to me and I'd talk to them. And then the last thing is that, last year, because of COVID, our pending bills were mostly dropped or sharply cut back. And so we're rerunning them this year and also running some bills that hadn't been introduced next year. So we're going to have a fairly heavy bill load this year. And we'll talk about the legislative program in a later memorandum, but just in terms of administration, to let you know that the staff is going to be a little strained for the next few months dealing with bills in addition to the study work that we do. And that's all I had for the executive director's report.
Thank you, Brian. With that said, that's a nice segue. Do any of the commissioners have any questions or suggestions that they wanted to put on the agenda for today? No? All right. We'll go ahead and
We do
move.
have a memo under the commissioner's suggestions, though.
Yeah, that's true.
Two.
We'll go ahead and go to Commissioner Carrillo's proposed suggestion that's highlighted or summarized in memorandum 2021-2.
And the idea is quite simple. It's the suggestion that Commissioner Carrillo has raised before that we put off to the first meeting of this year to change our the citation style we use for citing cases in the body of materials or in footnotes. As described in the memo, we would be instead using more of a citation style consistent with the California style manual rather than Blue Book. And the memo shows what that would look like and talks about in very general terms, advantages and disadvantages of changing the style. And I don't want to put my thumb on the scale any more than I might already have in the memo. So I'm not going to say more and just talk amongst yourselves and decide whether you want to do that.
I would say, I just because I'm the chair and I get to, I'm gonna race to say something. I just was curious and kind of took a browse through what I could find online in other commission memos. And I will say that this is a legislative style. So it's not so much as, just our particular commission's adoption of a style. So I would, I'm very much so that I appreciate Commissioner Carrillo's suggestion, because I get it. I'm not a fan of let's stick with what we've been doing because that's what we've been doing and it's not broken. If there was a good reason for the change, then I would totally be wholesale in support, but I'm not right now because I do think that it interrupts the legislative style. So that would just be.
Can I respond to that? Yeah, it seems to me like the concern of the memo is consistency, but the question is, what are you being consistent with? And it mentions being consistent with what's taught in law schools and academic journals. And I don't think that's what we should be striving for consistency with. We should be striving for consistency with the courts of California, which use California style manual. If we want to be cited in those courts, I think we should be using this style. It's a pretty common transition. Once you get out of law school, you never use Blue Book again because everyone in practice uses California style because that's what the courts use. So to me, Blue Book it's purely an artifact of the academic environment, which is not our primary audience.
Okay, and then I would just echo what I said before, though, because if you do just look at what's published online for the different commissions, you will see the Blue Book style. And so that would be just something that it's not so much that it's just, again, just the state just following what they learned from law school. If you cite to legislative reports or to committee reports, you'll see this exact style. So
I think that's a shame. This is a California commission doing California law in California. We should be doing California style.
Victor or Commissioner King?
Yeah, I want to weigh in that I led this effort at a law firm I was at. So I am very sympathetic to the mission of conforming to the California style. I find interesting comment that you said it's legislative style. Well, we are the commission that's most aligned with legislative work. So I think that enters in that favor. Here's the key thing for me. We do need consistency with the committee on the criminal issues, on the penal issues.
That's good.
So although I'm supportive of Commissioner Carrillo's suggestion, I think we need to be in lockstep with what the committee is doing because we are all in the same body. It's going to look very schizophrenic if we do two things differently. And in some ways, people are watching their work more carefully than our work right now because penal reform is such a hot topic in California. So I'm all for Commissioner Carrillo's suggestion, but only if there's buy-in from our sister organization.
Any other commissioners? Commissioner Simpson?
I guess I'm one of the only non-lawyers on here, so frankly, I'm not sure I have a strong feeling one way or the other. But it struck me, particularly as what Victor was saying, I don't know why the Committee on the Penal Code wouldn't be following the commission, of which they're sort of a subsidiary. Secondly, honestly, I'd kind of be interested in what Kara has to say, because, her organizations, it deals with, our legislative clients all the time. And, sort of what sort of style do they use in their legal opinions, if they're citing a court case in statute, that sort of thing.
Thank you. We do follow the California style with regard to our legal opinions that we issue. I know in statute, I just need to verify that. I know we have a weird, I'm not even sure it follows the Blue Book or California. I feel like we have a separate, our own office style in statute that we have followed for many years. So I'd have to go back and verify that. But I know for our legal opinions, we normally use the California.
AG's office also does for its AG opinions and internally.
But that makes sense. It's like Victor mentioned, it's state. They're conforming to the court style versus the legislative style, or what is used in legislative reports. So that makes sense. Anna, do you have any? And Commissioner Kuvas, she's also not a lawyer. So, and then I think we were missing one person, and so this is a good mix. We have a good mix of different people. We have research attorneys, and we have practicing attorneys, or so this is a good mix. So don't feel overwhelmed.
Thank you for asking for my opinion. I am not an attorney. I really don't have a strong opinion. However, one of my very first jobs out of grad school was working for the California Legislative Analyst's Office. And so I know that the current memo format and the way that we do things are similar to that, which was comforting to me, even the font. So I'm not inclined to make changes, but I look forward to the conversation. Obviously, I believe it's really a matter for the staff to weigh in terms of how they would like to continue to reflect and publish our work. I defer to them, really.
The chair.
I think the memo spoke to that. I'm just going to ask for Jane. Jane, do you have any, or Commissioner McAllister? Do you talking to you? I feel like I'm talking to my friends. Commissioner McAllister.
Well, it's really kind of a challenge in that sense that I absolutely hear what you're saying, Commissioner Carrillo. I do, and I understand it. I am concerned with a lack of consistency, just because, I mean, I guess the real issue is if we have inconsistent styles, let's say we go California style, are we going to have difficulty then with people who are trying to navigate how they present things to us? And I mean, and Commissioner King's point is also well taken, which is we should have uniformity between the two different arms of the commission. So, my initial thing was, my inclination was to leave it alone and not change it, and I'm still leaning that way a bit. I mean, I think I could be convinced otherwise possibly, but, if Ms. Jenkins didn't have a huge idea that we should change it and that would be beneficial for us to change it. I mean, I think her opinion actually resonates with me most at this point.
And I'm sorry, I can do some additional follow-up on that. I mean, personally, I feel since I'm new to the commission, I'm still trying to learn what we're doing here. And I wasn't prepared to weigh in on this today. But I can definitely look into it and report back if that's what the commission would like.
I think it's fair, and if I would just move, not to delay this issue, but it seems like it's simple in the proposal, but I don't think it would hurt. I will say that I was hoping that the report did do the comparison a little bit that I did when I just wanted to see what the other committees or commissions are using. Do we want to move this item and table it for the next meeting just to take a vote? Because it sounds like really everyone's saying, well, I could be inclined if, I could hear more. But if we took a vote right now, I don't, what would people agree to affirmatively without knowing what, our criminal arm is saying, or what the, Kara's, maybe there are other people in your unit. I can tell you, and I'm sure that Brian would probably say Diane, she would absolutely say no.
Crystal, why don't we table this for a little bit more information? It's also kind of a minor point, and I don't want to, I don't want to take up the commission's time with it.
Because honestly, I do think that the spirit behind it is important. I want the new commissioners to feel like if they have a suggestion that they're not being shot down by us saying, this is tradition. That is not a welcoming response. And I just don't like it. And we have a good amount of attendees and you guys are new. And I think that was what Victor and I were kind of, we're the senior members now. We want you guys to feel comfortable and to feel like this is your process as well.
No, I
So
get that, but this is
think if we
procedure rather than
No,
substance.
I'm saying, let's table it. And if you guys are in agreement with table, is that the consensus or?
Yeah,
just
oh,
looking-
can I make one more comment? Having been part of a law firm that made such a transition, 20 years ago, 25 years ago, it's not that big a deal. It's not, very time consuming. I mean, it's just literally, for the most part, changing some parentheticals to a different part of the citation. So I don't think we should oversell how difficult this would be or how much of a horrible change this would be. It's incredibly simple. But again, I would only be open to it if we do it in lockstep with the committee. I appreciate the fact that the perception is the committee is a subarm of the commission. But I think at this point in our state's history, the work of the committee is getting a lot more attention than our work right now. And we need to really follow their preference and lead on this, even though we're technically the larger body.
Before you table it, let me fill a couple of gaps in the information, and also express a personal preference that we not bring it back at a future meeting. If we think we know enough about this, then, it comes down to a fairly simple question. And I don't really want to have it drag out and spend another half an hour at a future meeting talking about the same stuff again. With respect to legislative practice, I could be wrong, Kara, but I believe that in statutes, you use California style to cite to cases. I Googled around a little bit while you were talking. I couldn't find examples, but that's my recollection. And with respect to the committee on the revision of the penal code, they don't have a lot of occasion to cite to cases since they're focusing on statutes. I looked at their first annual report and I was trying to see if I could find a case cite, and I couldn't. In their footnotes, they were citing to statutes mostly. And so there's not a strongly established practice there, but I did talk to the attorney who sort of is their lead attorney about this when it came up, noting that, what would you guys think? And he wasn't inclined to make the change just because, the minor nuisance of changing practice was enough to deter him. But I don't know that that's binds us at all. I don't know that people think of us as connected entities, even though formally we are. So, and they use Blue Book. To my knowledge, they don't use the California style. So I really think the issue is, I think, a question of consistency with past practice versus consistency with California, the predominant weight of California entities, right? Commissioner Creo is advocating for consistency with the legislature and consistency with the AG and other state entities that write legal documents, and he sees value in that. And the only thing to oppose that is just the weight of prior practice and the whatever value there is in having consistency with academic conventions and practices in other states, to the extent that other states use Blue Book rather than their own state style manual. And so, really, I don't see what more we're going to learn about this that's going to affect that basic question. And I'm open to people adding to that question or modifying it if you think that I've
Then let's call the question.
That'd be my inclination.
Who wants to call the question?
I just did.
I'll move that we leave the citation organization how it currently is without changing it.
Okay, all those in favor say aye. Aye.
I
So
see
there's,
two.
yeah, then Commissioner King and we can't see because of the virtual background. Okay, and then Commissioner
three.
Cuevas. There's 3 names.
There were 2 up thumbs, 3 down thumbs.
Okay.
Do we want
Oh.
to try and flip the motion? and see if.
You guys, wait, I can't see who's the other two, or it's myself and Jane, but Anna, did you vote?
Yeah,
I
she
can't see
voted to keep the same. So did you vote? I didn't
Okay,
see
so
you.
there's, yeah, I did. So there's three. We don't have, I was counting our votes too. Oh, yeah, there's the Kara's the fourth. Okay, good.
Well, Kara
And-
maybe has information.
Well, no, I'm going to abstain at this point because I
Then
I regret it.
because so we don't have any majority rule, so we
Then we
have,
have to table it. Let's
Yeah,
take this up at the next meeting. I feel like I'm causing trouble here.
all right, so.
I apologize for
we'll go
wasting
ahead.
everyone's time with this.
No.
No, that's fine. So we'll just table it. And look, we can do when Brian, I just moved that we, or not moved, but I proposed that you put this item again on the first, like one of the items. It will be anyway on the agenda because it's a commissioner suggestion.
Sure.
We won't take this much time to do it next time, so it's okay.
I'll
It won't take
recycle
that
the memo and I'll supplement it with any further information the legislative council gives me. And I'll talk to the folks on the committee side to see if they have a view. And what their intended practice is. And I'll put all that information and we can just maybe do a vote only.
No, that's good.
I want
And that's
silence.
what let's commit to doing that, and it won't take long. All right, so we'll go to the next item, the open government laws, memo 2021-3.
Good morning, everyone. That's mine. Nice to see everyone again.
Good morning, Steve.
Commissioner Jenkins, nice to see you. So this is a purely informational annual memo. Doesn't require any decisions. It's just meant to keep everyone updated about open government statutes. You know, most specifically open meeting laws, conflict of interest, and also public records. There's nothing really new to report over this past year. So the memo is pretty much exactly the same memo you saw at the beginning of last year. The only real difference this year were the executive orders from the governor with regard to doing meetings the way we're doing them. But other than that, unless anyone has any questions, there's nothing else we need to talk about relating to this memo. And are there any questions? Seeing no questions. All right.
Well, no,
And-
hold on. Do the new commissioners have any questions? Because actually, there's no like real risk unless people are meeting in secret, Zoom rooms or online. But when we're meeting with face to face, then this rule that seems kind of, abstract, but it occurs when you're in the car on the way to the airport. It can occur when you're just walking for lunch. So it is an important rule to look at and to understand and appreciate. Commissioner Simpson.
Well, I'll just say, I don't know questions. I just appreciate the sort of update and insight from Steve. In my 35 plus years in the legislature, we weren't subject to the open meetings requirements that everybody else is. In my 6.5, 7 years on the Commission on Judicial Performance, we're not subject to that stuff either. So this is kind of new to me, so I appreciate the insight.
Sure.
Yeah, it does come up. It actually does come up.
We do the same thing on the committee side. We do did a memo for them last year, and it's the same kind of thing. They've got 2 legislative members. They've got 2 members who were formerly judges or justices. And yeah, it's new to some people and kind of surprising and good to know, so you don't accidentally step on
Right.
something you shouldn't. And I would add a reminder that the reason why we're seeing Steve just for such a small piece of the work for this meeting is because he's also been cross-assigned as a contact tracer. So most of his time is dedicated to that, and he's fitting commission work in where he can. And I appreciate that.
Thank you from the state of
All
California
right.
people. Thank you, Steve.
All
Figuring
right.
out
Well,
what's
thank you
going on.
very much.
Thank you. We'll go ahead and go to the next item, item number 4, which is memo 2021-5.
-4, I believe, the legislative program.
Sorry, guys, I skipped
That's
that.
right. As I mentioned, we've got a pretty significant legislative program this year because we're picking up bills that were dropped last year and rerunning them. For the most part, we were successful in finding authors. There are a few points that are worth talking about. The memo itself and the table that's attached to it gives you an overview of where things stand. And of course, nothing's been heard in committee yet, so they're all just introduced. One proposal that fell out was the commission's proposals of miscellaneous changes to the creditor claim rules for procedures for disposition of an estate without administration. That proposal was sort of a spin-off of the commission's work on revocable transfer on death deeds. And so Senator Roth is authoring our RTOD bill this year, again, as he did last year. And I had been talking to his staff about the possibility of him combining that with the disposition, the creditor claims on disposition of estate without administration, because there is some overlap. That did not work out, but I think that's okay, because originally the intention was that the revocable transfer on death deed bill be before the legislature first, because the other proposal, like I said, is derivative of it. And so there's some benefit in letting them see the issues and then coming back with a modified version of it the next year. And so that's probably what we're going to do, is we'll just find an author next year for these related estate planning proposals. More significantly, at a prior meeting, it was suggested that the commission should study the complexities of interstate reciprocity for higher education. And the decision was made to, we didn't have authority to study that topic. So the decision was made to request that authority in this year's resolution that sets the commission's main calendar of topics authorized for study. And Assemblymember Chow is authoring that resolution. But prior to the introduction of the resolution, there were legislative staff outside of Mr. Chow's office reached out to me and requested the chance to talk to me about that idea, that proposal, which is unusual. It's a little surprising they'd heard about it, because usually they are, our meetings are public, but they're not necessarily well attended by legislative staff. But it was also interesting to me that they wanted to talk about it. And I had conversations actually with people from a couple of different parts of the legislature, and the sense that I gathered from those conversations, and unfortunately, I'm not free to share the details. They were asked that they be confidential conversations, but it became clear to me that the legislature would rather that we not work on that topic. And considering that that we get our authority from the legislature, they set our agenda, and we were specifically proposing to ask them for a grant of authority, and I got guidance that that grant would not be made, that if we asked for it, the answer would be no. I didn't see a lot of point in persisting by putting it into the resolution and then getting it knocked down. I spoke with the chair, as is our practice, to discuss possible changes to commission recommendations in the legislature, and filled her in about the same level of generality that I'm using now. And her reaction was the same, which is, that it might be imprudent in a couple of ways to push for authority that we've been informally told we weren't going to get. So that's why that has dropped out. And I understand that that's a disappointment, because the commission was interested in trying to make progress on that topic. But, that's the consequence of the fact that they decide what they want us to work on. The only other piece on the legislative program is that the Public Records Act bills that were reintroduced, there were a number of changes that needed to be made to address legislation affecting those provisions in 2020 to update for the effect of those bills. And Barbara did a huge amount of meticulous work to bring those proposals up to speed. And some of those changes she's already shown you, but there are others that will need to be run by you. And we will do that in a future memorandum. Is that correct, Barbara? Is that where it stands?
Yes, that's exactly where it stands. And I apologize that I wasn't able to sort of put all those changes into, summarize them for you for this meeting. But I will be able to do that for the next meeting. It's top of my priority list at this point. And there are purely technical things to make adjustments for the fact that various code sections that we're making conforming revisions in, changes were made to those code sections last year, or in some cases, there were provisions that in the codes that referred to the Public Records Act that we weren't aware of and needed to be added to the conforming revisions bill. So they're not anything that really is a very exciting or different. It's just a matter of making sure that you're aware of the changes and okay with them.
So that memorandum doesn't present anything for commission decision on the legislative program. It's informational only, but if anyone has any questions or anything they want to discuss about it, now would be the time. No? Okay, it's going to keep us busy, I think. Unless they decide to pare the legislature's workload back further due to COVID, but hopefully not. Hopefully we're on the upswing.
Yeah, let's knock on wood on that.
So that's all I have on that memorandum.
Okay. Carrie, you had a question?
I'm sorry, I do have additional information on the citation style. I don't know if it's appropriate to go back to that right now.
Why don't you just email it to me? Because I was going to put together a memo with the filling the informational gaps for next meeting.
Okay, will do.
Thank you.
Thank you. All right, then let's go ahead and go to the stock cooperatives. And also too, do we know if there are any attendees that are are here for certain topics, Brian?
So far, we haven't presented much that would be of interest to the public, except maybe the legislative program. I don't see any names for people, and nobody raised their hand during that discussion. So I suspect this will be the first item where we might have public comment, because it is the first substantive item on the agenda.
Okay.
The
Then
next
let's
one.
go ahead and move forward then on its study L3032.5. And it's memorandum 2021-5, and it's on stock cooperatives and the Uniform Transfer on Death Security Registration Act.
Thank you. That's my memo as well. And just to recap, this is also derivative of the Commission's work on revocable transfer on death deeds. When we were assigned the follow-up study for revocable transfer on death deeds, one of the questions that was specifically posed by the legislature is whether the law should allow them to be used to transfer an interest in a stock cooperative. And when we submitted our recommendation to the legislature on that point, our answer was no. It should not be, because there are differences in form between a stock cooperative and other kinds of real property ownership schemes that are a poor fit for a transfer system based on deeds. Because stock co-ops, the individual owners who acquire like apartments or whatever they call them in stock co-ops, don't hold deeds to that property. They own shares of stock. The corporation itself owns the whole development, and the individual separate interest holders only have a share of stock, and it may also be supplemented by various agreements between the individual and the stock co-op. Occupancy agreements, proprietary leases. And so when the commission concluded that the revocable transfer on death deed should not apply to stock cooperatives. It nonetheless also decided that it would conduct a study of whether there is some other conveyancing scheme that we could come up with so that people in stock co-ops are not left without the benefit of a similar kind of easily executed transfer on death mechanism. And that's what we've been building in this study. And we looked to a couple of different sources for inspiration. One was the Uniform TOD Security Registration Act, which is in existing California law. It's a uniform act and allows for the registration of securities in TOD form. And then when the owner dies, they transfer to a named beneficiary through a process overseen by the registering entity, which is either the company that sold the share of stock or a stockbroker. And then as a consequence of that re-registration, then the beneficiary is now the owner. And that happens privately outside the courts. So we looked at that as a possible mechanism. We've also been looking at the revocable transfer on death deed statute itself, because that was the original RTOD deed statute was prepared by the commission pursuant to a study assigned to us by the legislature. And I think it's actually a sort of a useful microcosm of transfer on death law. When we were evaluating the concept of allowing for that, the staff, who was then, the work was done by Nat Sterling, who I mentioned earlier in the meeting, had to go through sort of the universe of substantive issues that are presented with any kind of transfer on death, extrajudicial transfer on death mechanism. And so we really did like hit all the substantive points that we thought were necessary to cover that concept and not leave significant gaps. So considering that that's out there as a model, we're looking to that as a source as well. Not where there are differences between a stock co-op and other kinds of property that require different treatment, but where there isn't such a difference, where it's just an issue that relates to a transfer of real property generally, then we're looking to that statute as sort of a presumptive source of law on substantive issues. We've been doing that. We've been working through most of the issues. We're now down, I believe, to the last two areas addressed by the RTOD deed statute that we haven't talked about yet. Contests. So what should be the statutory rules for contesting a registration of a stock co-op interest in TOD form? That would be like filing an action in the court to challenge the validity and try and void the transfer. And then the other issue is the relationship between a registration in TOD form and other instruments or forms of ownership that purport to transfer the same property on death. So if you've registered and transfer on death form, but you've also got a will, which controls to the extent they're inconsistent, or you've got a registration and transfer on death form, but your ownership was in joint tenancy. And so there's a right of survivorship, which controls. And so both of those are areas that were addressed in detail by the RTOD deed statute. And so I'm mostly just working through and discussing whether the same approach would be appropriate for the tentative recommendation that we're building. So contests, I think, is the easier one. And the provisions on contesting an RTOD deed are set out on pages, in the memo on pages 2 to 3, and then summarized in a bullet list on page 4. And my general recommendation, I'm not going to walk through those, but I'm happy to answer questions if you have any. My general recommendation is that those are well thought out rules that cover the ground we need to cover in a sensible way. And so with one exception that I'll get to in a second, my recommendation is that we just crib from the RTOD deed statute and put similar provisions into the statute we're building for stock co-ops. The only exception is a minor one, which is in our study of the RTOD deed follow-up that we did, we recommended an improvement to one of the contest statutes by adding express language, making clear that it covers the contest of a revocation as well as the contest of the RTOD deed itself. So, you know, it's possible that a bad actor could trick or coerce someone into creating an RTOD deed, or they could also trick or coerce someone into revoking one that they intentionally created. You know, the fraud could run in both of those directions depending on the posture of the person that the fraudster is acting on. So in that other study, we recommended adding language, which is shown at the top of page 5, to make clear that the provision on standing to contest also applies to contest of a revocation. So my aggregate recommendation in the memo is we should adopt the rules that the commission approved for the RTOD deed, including the modification that we approved just I think last year in the follow-up study. So with that, if anyone has questions or observations about any of the specifics they want to discuss, I'm happy to talk about them. If not, then you know, if someone is willing to make the motion, my recommendation is that, as I said, we approve the slate of provisions as modified by our follow-up recommendation.
So moved.
Second.
I'll second. Commissioner Simpson seconded it. All those in favor say aye.
Aye.
I was going to say I saw a lot of head nods, so by consent it passes.
Okay, and I didn't see any abstentions or no.
No,
votes
everyone voted aye.
or absences. Everybody's here. Good. Okay. The next set of issues is a little more complicated. They have to do with, like I said, other instruments and forms of ownership that are in conflict with a registration in TOD form. And again, starting on page 5, I set out the provisions in the RTOD deed statute that address that topic. With respect to conflicting instruments, the rules are set out in existing section 5660. And I think it probably is worth just like quickly moving through and summarizing how that works. Under that statute, a revocable transfer on death deed is only valid if it's recorded in a specified time period. So the rule starts by saying if the revocable transfer on death deed is otherwise valid, it's recorded. What do you do with a conflicting instrument? Subdivision A says if the other instrument is not recorded, then the RTOD deed controls. So the general rule is the RTOD deed controls over any other instruments that aren't of record in the county property records. And as I say, that is a practical necessity for RTOD deeds because we're relying on title records and the title insurers as a way of establishing the marketability of property transferred by RTOD deed. We're not relying on the courts. So it has to be determinable from public records to the point where the title insurers are willing to guarantee good title. So that's rule A. I would recommend the same. Well, let me just go through B and C and then I'll get into the specifics. B says if the other instrument is recorded, so both the RTOD deed and the conflicting instrument are recorded, and the other instrument is revocable, as an RTOD deed is, then the latest executed instrument controls. So if they're both of record and revocable, then they have the same practical posture, and there's no practical reason to prefer one over the other. So by preferring the later executed, what you're doing is you're trying to effectuate what is probably the transferor's intent, on the assumption that the most recent expression of their intent is probably what they were thinking at the time that they died. And so that's rule B. All other considerations being equal, prefer the last executed. And then rule C is, if both instruments are recorded and the conflicting instrument is irrevocable, then the irrevocable instrument controls. So like you create this RTOD deed that's a revocable instrument that doesn't operate until your death. And then 2 years later, you execute an irrevocable trust and transfer the property into that trust. That locks it up. That creates a practical, I mean, there are ways to get around irrevocable trusts, but in general, that creates a practical reason to prefer the irrevocable instrument, because it's, in a sense, a surrender of your freedom to do other things with the property. You've chosen to put it into a form that you can't modify. So that's rule C. So that's all for the RTOD deed. And my recommendation generally is that we follow the same approach for TOD registration of an interest in a stock co-op. There are a couple of wrinkles that the memo talks about. First, at a prior meeting, the commission decided not to require recordation of a registration of a TOD, in TOD form, of an interest in a stock co-op. That was in the discussion of authentication. And the conclusion was that the fact that registration also involves a third party, the registering entity, and signatures by both the transferor and an agent of the registering entity, that was sufficient for the purposes of authentication to establish the authenticity of the instrument. When I wrote that memo and we had that conversation, I hadn't yet thought ahead to how this plays out in the context of conflicting instruments. And here, as explained in the memo, I actually think there is reason to require recordation of a TOD registration for a stock co-op. Specifically, there will be instances, it's not ubiquitous, but there will be instances where you require title insurance for the transfer of an interest in a stock co-op. If the title insurer goes in and looks at the record in the county recorder's office, and they see a conflicting instrument of record, like a trust, but they don't see the TOD registration, they're not going to know to apply a rule that says, well, the TOD registration was the latest executed, therefore it controls. They won't have that information available to them in the county records. They won't be able to figure out, they won't even know that there is a conflict. They'll just presume the correctness of the instrument that's in the county records, because there's nothing of record inconsistent with that. So if we were to follow the approach in the RTOD deed statute, but not require recordation of the TOD registration, the thing would collapse. Because the information about the TOD registration would not be of record, and title insurers wouldn't have the information they need to resolve conflicts or even know that there is a conflict. So that's the first point where I think I need a decision. If the commission agrees that we ought to generally follow the model of section 5660 in terms of preferring recorded over unrecorded, preferring latest executed where everything else is equal, preferring irrevocable where everything else is equal. If we're going to follow that approach, I'm now recommending that the statute require recordation of a TOD registration of a stock co-op to be effective. Does anyone want to discuss that or sees it differently or has questions?
No, I'm kind of looking at Jane, because I know that I think, and Victor too, I think the goal, I'm glad, Brian, you did a great job on this memo, because it caught a big whoops, because that was not our goal. We were trying to streamline the process. I think that was something that we all kind of were in agreement. And you're right, what to do. And you raised great questions, because it is true. It's like we created a hole by trying to streamline it. So I'm in agreement with your proposed change.
It makes perfect sense. It makes great sense. And I think that it was, it's such an anomaly in the, I mean, it's a weird thing, stock co-ops. So, you know, we were trying to make sure that it wasn't unduly burdensome to people who were trying to transfer things and creating things, but I don't see a way around
The
requiring.
title insurance. I know, you have to. We
I
were
would
trying to
move
help.
that we mirror the provisions and require a recordation.
I thought of it, I don't want to like upset the apple cart since you're all in agreement, it seems. But I thought of another reason, another benefit of requiring recordation. And this has to do with an issue that Steve Cohen came up with when he was doing some work earlier on this study, which is like, it relies on the stock co-op to keep good records, right? If it's an purely private exchange of instruments between the stock co-op and the decedent, and the stock co-op has bad business practices and they lose the thing, then nobody knows that it was ever registered in that form. So
You
putting
imagine?
it in the property records is a way of at least publicly memorializing them, if nothing else. So I don't, like I said, I don't want to reopen the topic since it looks like there's consensus. So I will move on.
And I think that speaks well to your good work. Honestly, it was well written, very clear, and I think we all remembered. And honestly, the people that we had who shared their interest and joined us, the public comment was helpful too. I think we've seen enough of a glimpse to know we need to take steps to make sure that interests are protected.
Then thank you. The next issue has to do with timing. The section 5660 in the revocable transfer on death deed statute talks about an instrument that's recorded before the transferor's death. So all of the rules for resolving conflicts with conflicting instruments turn in part on whether it's of record before the transferor's death. And we've discussed issues like this before. The reason for that tight timing rule is that title insurers don't want things to be uncertain at the time they're being asked to insure a good title. So if it was possible for a conflicting instrument to pop up in the record sometime after a date certain and be given effect under the conflict rules, then the title insurer can't know whether title is good or not until the date for such instruments popping up has been closed. So there has to be an end date that is certain for the record to be certain. And at the time that we were doing the revocable transfer on death deed, the desire was to avoid a protracted period of a cloud on title after death, a limited marketability. So if, for example, you could give effect to a conflicting instrument that was recorded within 60 days after the transferor's death, you're not going to be able to get title insurance during that 60 days. Title insurers will decline because they're going to wait for that date certain to come so they know there are no surprises that could affect the validity of title. So the statute for RTOD deeds said transferor's death, that's the date certain. What I point out here is that that doesn't have to be the date. There has to be one, but it doesn't have to be the date of the transferor's death. And we have been in the RTOD deed study, moving away from the date of the transferor's death as the date certain for all kinds of issues, related issues. And that we've been moving to 120 days after the transferor's death. And the reason for that is that under the revocable transfer on death deed statute, rules on contests, which we just discussed and you just approved, there is a rule that says that any person can record a notice of action, a lis pendens, up to 120 days after the transferor's death that gives public notice of a contest. Okay, so if you think the RTOD deed is invalid and you're going to challenge it in court and you file your action to contest it in court, you can record notice of that action in the public record for that property. And under the RTOD deed statute, that has a significant effect. There's a provision that talks about what kind of relief a court can give in a contest action, a successful contest action for the RTOD deeds. And the rule is that if the action was filed and a lis pendens was recorded within 120 days after the transferor's death, the court can void the RTOD deed. That's the available remedy. And I think it even says shall void it. So it's like it's a nullity and the property transfers according to other law or other instruments. Now that would be true even if the beneficiary sold the property to somebody else on day 60, right? So there's a 120-day period during which you can record your lis pendens and preserve the ability of the court to void the deed. If you sell the property before that 120 days runs, there is no protection for a bona fide purchaser or encumbrancer. So if I come in, they refinance and the bank says, yeah, I'll loan you with this as collateral, beneficiary who received the property pursuant to an RTOD deed, or I'll buy the property from you, beneficiary. You do that during that 120 days, you're taking a risk that somebody's going to record a lis pendens that will preserve the court's ability to void the deed, and you will not have BFP protection during that period. That's the way the statute is structured. So there is already a 120-day period after the transferor's death during which title insurers are not going to want to issue policies, because they know that until that 120 days runs, at any point a lis pendens could pop up and preserve the possibility that the deed is a legal nullity. They could void it. And so there's no certainty that the beneficiary's title is good until that possibility is foreclosed. And the statute says if there was no lis pendens recorded in 120 days, then a BFP is protected from so long as it wasn't recorded before they acquired property. So there's a little bit of a wiggle room there in terms of actual notice. But the 120 days is the operative period. That is the minimum period of impaired marketability under the RTOD deed statute. So we, in the follow-up study, did some tweaks to the RTOD deed statute to sort of take advantage of that 120-day window and preserve some rights of other interested people during that period, because there's no downside to doing it. You've already got a cloud on title that's going to block the issuance of title insurance. So the same thing is true here. These conflict rules currently say your conflicting instrument is only good if it's recorded before the transferor's death. It could say your instrument is only good if it's recorded within 120 days of the transferor's death. There would be no significant disadvantage to pushing that date out, because that is already a blackout period during which you're not going to be able to get title insurance. What's the advantage of doing it? Well, you create an opening for preserving instruments that turn out to be valid under the conflict rules. So let's say there's an RTOD deed, transferor dies. Turns out they also had executed an inconsistent trust. Somebody brings it in the week after the transferor's death because they found it, they've learned about it for the first time, looking at the person's affairs. They bring it in and record it. It was the later executed instrument, so under the policy of 5660, it should be presumed the better expression of the transferor's intention. Why not allow that? Why cut it off at the transferor's death if there is an opportunity to extend that period out for 120 days? And could be a real important opportunity, because, you know, TOD registration is going to be a mostly private thing. A lot of times people don't know what their relatives are up to with their estates until after they've died. And you go in and you start putting their papers in order and you go, oh, well, what is this? And so creating an opening for people who are interested in the estate to take a look at the estate discover instruments that are purportedly valid and take the step to record it so that it controls, there's value in that. I think the cutting it off at death is an artificial date. So is 120 days an artificial date, but that's a date that the law has already struck as creating this approximately 4-month period for people to get things in order. So my second recommendation is that in addition to requiring recordation, that we modify the rules on conflicting instruments so that they key off of instruments that are in the record within 120 days of death rather than at the time of death. Does anyone want to talk about that or see it differently?
Jane?
I think it's a good idea. I think it would introduce a level of certainty that would be instrumental in trying to make sure that there isn't a lot of extreme, I think about it in terms of like the creditor claim period for a probate, right? That's not limited by date of death. You have an extension of time so that the court can adjudicate and be positive that the disposition of the estate is final and complete. So I like your analysis. I think it's good. I think we should do it. And it would be in conformance with what's already there. So it's not like it's some, strange theory that we're trying to do. And it actually, like I said, I feel like it also mirrors what's already the practice in the probate code for adjudicating claims or other things like that. So that would be my take on it.
Did you want to
Anybody
say
have
something?
questions or a different view?
Commissioner Simpson? No? No? Okay. And then I'm with Commissioner McAllister. I like it. I always think about, just the bar exam is like, basically, if you remember 120 days, you should be able to get through all the probate questions. And it's true. And I have done work in this area. The 120 days is significant, and it does give people time to grieve and then to kind of say, okay, now what do I have in front of me? And it also allows for other claims to seep through. So I think it's a good idea. And I like the analysis.
So there's a related question, which has to do with, should we push that reform into the RTOD deed statute? Well, there's a bill pending for RTOD deed, and we missed it. I mean, I didn't see that issue until I did the analysis in this context. And when I said that we'd already sort of pushed things out to 120 days, the example I had in mind, and this is a proposal that we're making in the RTOD deed statute. The existing RTOD deed statute that says has a provision on the effect of a transfer on death deed that says that the beneficiary receives the property subject to any interests that are of record at the time of the transferor's death. So if there's a lien that was recorded before the transferor dies, the beneficiary takes the property subject to that lien. Okay. The commission, in the pending bill and our recommendation on RTOD deed follow-up, recommended pushing that out to 120 days for the same reason I just articulated, that it parallels the lis pendens period. So if the bill is enacted and the legislature agrees with our reform, it will say a beneficiary takes property under an RTOD deed subject to any interest that is of record within 120 days of the transferor's death. And the reasoning, like I said, is the same. It gives people who have interests in the property but don't know that it was subject to an RTOD deed and discover that after the transferor's death, to hurry down to the recorder's office and say, wait a minute, I've got an interest in that property that needs to be protected, and I'm going to record this in order to preserve it. And so we're proposing, like, the express reason the commission originally limited it to the date of the transferor's death was to avoid a period of impaired marketability. But that ship has sailed. The lis pendens period creates that period of impaired marketability. And so there really isn't any disadvantage to adding other obstacles to title during the same period. There's no longer a reason to artificially cut those interests off at the time of the transferor's death. That's the reasoning in this study, and having worked through the implications in the context of these conflicting instrument rules I realized that we probably should have done the same thing to RTOD deeds. I hadn't, when I was thinking all this through, seen how that issue loops back and touches on section 5660. So the bill is pending, and if you're interested in doing this, I can go to the author and explain it and ask them to amend the bill to put that change in. And it hasn't been heard yet, so it's still a good time for that to happen.
All
So
those in favor? I know. Is it, I think all of us are consenting to it. Is that correct? Okay, good. Yeah, Brian, you need to do that. And I'll just say that I have done, my first area was real estate, and then the list pendants issue was one of my first cases. But that is really, it feels different than the traditional trust and estates. And that's probably why we missed it, because that's just one of those areas that crosses over and it's just difficult to catch. So we missed it. That's all.
So I have
All
a
of us as
question.
a group, we were here, that we had, public comments. We missed it. So I'm glad you caught it.
I don't see Victor King showing up as a participant right now. Oh, there you are.
Oh, no,
Sorry.
he's here. And he
Okay.
did thumbs up.
Cool. Did I see a hand up?
He's enjoying not being the chair. He's having a fun time over there working. I see you. We're good.
Okay. Did Commissioner McAllister have something to say?
No, I think I hear what you're saying, Commissioner Miller O'Brien. I think that, the original intent with the ROTD was to try to streamline the process. And so we weren't thinking in terms of extended periods, because you wanted to be able to have people not spend great amounts of money, and they could, use this mechanism to transfer their estates. So now it makes a lot of sense. But traditionally that kind of hasn't been the way that we viewed those particular ways of transferring property. At least not in my practice experience. It was a way to just pretty much, do this, get it done in a very short period of time, because it's not used for big estates, right? So anyway.
And I honestly, I think all of us, there was, I think Brian had a death, I had a death, Victor had a death. We were like, this was really close to home, and we were like, no, it needs to be streamlined. But now having, hindsight gives you 20/20, right? Perspective, and this would have been a mistake.
Okay, so with that, there are two more issues that need to be resolved in this memo. I think they're easier to explain and consider. First, has to do with other forms of ownership. Like I said at the outset, one of the issues that the RTOD deed statute addresses is what is the result if the property is held in a form that has a right of survivorship, and does the execution of the RTOD deed trump that right of survivorship, or vice versa? And for the non-lawyers, right of survivorship, like with joint tenancy, it just means that when you jointly own property with a right of survivorship and one of the joint owners dies, their share is absorbed by the surviving joint owners. So if it's like two people, married couple with a joint tenancy, one dies, the other one assumes full ownership of the property by survivorship, so by operation of law. So the question that's asked and answered in the RTOD deed statute is, what is the effect on an RTOD deed if the underlying property to be transferred is held in a form that includes a right of survivorship? And that's joint tenancy. In California, it's generally joint tenancy, and now a new form of property ownership. I say new, but it's probably 20 years. Community property with right of survivorship. When the commission made its recommendation, it was essentially, I believe, based on trying to divine the transferor's most likely intention. Like, what did they mean to do? And the commission's conclusion was, well, the RTOD deed is an express instrument that's executed after you acquired the interest in the property in joint form. So it's probably the better expression of your interest, of your intentions. Yeah, you bought it in joint, you entitled it in joint tenancy form, but later you executed this instrument that wasn't joint tenancy, it was RTOD deed. The legislature specifically reversed us on that point. They concluded that the joint tenancy survivorship and community property with right of survivorship should control over the RTOD deed. And so we went in with legislative language saying the RTOD deed prevails. That was amended to the opposite rule. For the sake of consistency with the RTOD deed statute and consistency with the legislature's express view on which they believe is the correct result, my recommendation is that we parallel the existing RTOD deed statute on this issue, which is survivorship will control over the RTOD deed, over the TOD registration of a stock co-op interest. Does anyone see it differently? Okay, is there general assent?
Yes.
Okay. Last issue on this memo, there are in existing law some rules on non-probate transfer of spousal property, of community property. And I don't even want to think about the complexities that exist under that law, but the basic rule is that if you're going to transfer community property on death by non-probate means, you have to have the consent of your spouse in a specified form. They have to consent to the transfer. The RTOD deed statute has provision that says those rules apply. And I believe they would apply even without that provision because the RTOD deed effects a non-probate transfer, and those are general law on non-probate transfers. So I think it's just advisory more than anything. And so I think that those rules would apply to what we're working on too. By their own terms, they would apply to a transfer on death of an interest in a stock co-op. And so my recommendation would be that we include a parallel provision to what's in the RTOD deed statute that just basically says, by the way, those rules apply. Does anyone have any concerns about that? Okay. So that's all the decisions in this memo. And with them made, the next step I'm going to take is to put together a draft statute that accumulates all the decisions that have been made to date. Commissioner Simpson?
I was just wondering, I noticed we've got a bunch of people in the audience, if there was any public comment, that was all.
They don't have any
Anybody on
hands
this one?
raised. I know. Does anyone want to raise a hand?
Okay, yeah, I suspect that the stuff we talked about today is pretty non-controversial. And so the bar will get to see this in statute form. And a lot of times when it's in that kind of black and white form, that's when you get good comments and the interest level rises. So like I said, my next step is going to be to put together a draft of a tentative recommendation. And then once that's approved, then it will go out for public comment. We're on track, assuming that the public comment process does not consume a lot of time. We should be on track to finish this year, probably pretty quickly, and have a bill ready for next year. So that concludes that memo. Thank you. What's up next, folks?
I believe that's me.
Oh, you guys can't even hear me. I'm sorry. Do we need a break? That's what I thought we were. I asked if do anyone need a 10-minute break?
I'm seeing a thumb up.
Okay, good. Okay, just a 10-minute break, just because we're in the middle of the agenda, so that's fine.
Okay.
Back at what, 11? Okay. Thanks, Brian. I'm sorry, Kristen.
Sure, no problem.
How are you doing, Rick? Oh, are we being recorded right now, Brian? We are.
Absolutely, yes.
Yeah, so
I'm
talk to
doing
you. Good.
In fact, I get my second Pfizer dose on Sunday.
Good. How do you feel?
Oh, fine. Yeah, no side effects at all from the first.
Awesome.
Yeah, my wife got hers last Sunday, second dose, and no side effects. So
All right, you guys. I think
Okay.
we'll just check out
Yeah.
until we come back.
I'm gonna share a little intermission screen here.
Okay, good. So organized, Brian.
Well, thanks. Are you seeing it?
Yes, it looks good.
Okay. All right. Back at 11.